Hello Standard 10. Let's continue with our civics portion, and we are doing judiciary. So today we are going to continue with the appointment of judges. Okay, the last thing that we did was, in my last module I gave you a full chart for the subordinate courts and the single integrated system of the judiciary that we have completed, and I have done all the judicial terms also with you. Okay, so let's start with the appointment of the judges. Now before I begin, you can take a picture of this, because I've drawn a parallel between the High Court and the Supreme Court. I hope you can see it. Okay. Got it. So that's it. So first we are going to start with the appointment of the judges of the Supreme Court and the High Court. Okay, you also open your textbooks to the relevant pages so that we get a chance to see both. Yes, keep your textbooks also open, children. We'll refer to the textbook also. Okay, so let's start with the judiciary. First of all, it comes the Supreme Court and the High Court. I've given you the two. I've given you the bifurcation of the two. It composes of. So what does the Supreme Court compose of? The judges in the Supreme Court composes of the CJI. That means the Chief Justice of India. Okay, so it is the CJI, and there should not be more than 33 judges. So until the Parliament decides on something else and the number of the judges is made different, there will be not more than 33 judges. There is no such law which says there should be 33 judges. It is not more than 33 judges. When you are doing civics or when you are doing the judiciary especially, please remember not to change the words. The words have to be exactly as they are. So the words are not more than 33 judges until the Parliament by law prescribes a larger number. Okay, this is the Supreme Court. In the High Court, we have the Chief Justice. You are the Chief Justice of the High Court. Okay, the other one is the CJI, is the Chief Justice of India. Here we have the Chief Justice of that particular High Court, whichever High Court you are attending to. Then the other judges are appointed by the press. Now please remember, I have used short forms. So unless and until you attend my lecture or you see my module, my notes may not be helpful to you. So by the press over here, I mean President. So other judges are appointed by the President from time to time. The President can also appoint additional temporary judges for 2 years to clear the arrears. The President can appoint an acting judge when a permanent judge is absent. So if a permanent judge is absent for some reason, then the President can appoint an acting judge. Okay, and from time to time he can appoint judges, additional judges. Now what are the qualifications required? He has to be a citizen of India. For the Supreme Court, citizen of India, been a judge of any High Court for at least 5 years. Now this is little tricky. It does not mean that you have to be a judge of the High Court for 5 years, yes, but not at one particular High Court. You can be in succession, but supposing like you have been a judge at 2 different High Courts, but it has to be a continuous period of 5 years. Okay, because we later on come to the transfer of judges also. So a judge can also be transferred. So in those circumstances, it has to be a continuous amount of 5 years. Okay, so you have to be a judge of the High Court for 5 years, or he has to be an advocate of a High Court for 10 years. So if he has not been a judge, he has to at least have had practice for 10 years in any High Court. Is in the opinion of the President a distinguished jurist, and he should not be more than 65 years of age. So the maximum age should be for a Supreme Court judge should be 65 years. Now we come to the High Court. What are the similarities? Citizen of India is same for both. Now here it is 65 years, and for High Court it is 62 years. Okay, so High Court is 62 years. He has been an advocate of the High Court for at least 10 years, both the cases. So that is a common point. Or he has had a judicial office in India for 10 years. So if he has not been an advocate for 10 years, but if he has held some judicial office in India for minimum 10 years, then he can become the High Court judge. Okay, now how is he appointed? Appointment is by the President of India. We are talking about the Supreme Court. By the President of India in consultation with the current judges of the High Court, the Supreme Court and the Council of Ministers. So all these have to be consulted and taken into account their opinion before he decides the President appoints somebody as a Chief Justice of India. After that, for the High Court, we have the Chief Justice of a High Court is appointed by the President of India in consultation with the CJI. So once the CJI means a Chief Justice of the Supreme Court is appointed with his consultation, only then can you appoint the judge of the High Court. So the Chief Justice of the High Court is appointed by the President of India in consultation with the CJI and the governor of that particular state. You have to also consult the governor of that particular state before appointing him as a Chief Justice of a particular High Court. Supposing we talk about Maharashtra. So then the Chief Justice of India has to be consulted. Who are the people involved? The Chief Justice of India, the Governor of Maharashtra, because I'm giving you an example of Maharashtra. So governor of that particular state, and of course the President. He will appoint the judge. Okay. Then as far as the Supreme Court is concerned, all judges other than the CJI. So when you are appointing the CJI, we have done his appointment earlier. Okay. So now when you are appointing the other judges of the Supreme Court, the CJI means the Chief Justice of India will be appointed only after consultation with the CJI. So the other judges will be appointed. Okay. Usually the senior most judge of the Supreme Court is appointed as the CJI. Okay. Then we come to the High Court. All other judges are appointed by the President in consultation with the CJI and the Chief Justice of that particular High Court and the Governor of the state. So where as far as the High Court is concerned, the Governor of the state is involved in the appointment of not only the Chief Justice of that particular High Court, but also the other judges of that High Court. Okay. And as far as the Supreme Court is concerned, generally the senior most judge is appointed. I hope this is clear. And Council of Ministers are involved over here for the Supreme Court. For the High Court, the Governor is involved. Now the term of office. Now we come to the term of office. The term of office of a judge of a Supreme Court is 65 years, and he can resign by submitting a resignation to the President of India, or he can be removed by the process of impeachment and in no other way. There is an entire process. If you want to remove a judge, then you have to follow that procedure, failing which you cannot remove a judge. A judge cannot be removed at somebody's whims and fancies. Okay. So and he can stay there till 65 years. Then the High Court judge. What happens to the High Court judge? He can be there till the age of 62 years, and he can resign by submitting a resignation to the CJ. Who is the CJ? Chief Justice of the High Court, or to the CJI, Chief Justice of India, or to the President. And he can also be removed by the process of impeachment. And he can be removed if he is being transferred to another court. Okay. Say, understood? Yep. Okay. Now there is something which we call as an ad hoc judge. What is an ad hoc judge? See, if the CJI realizes in the Supreme Court that there is a lot of backlog of cases or something, and he deems it is in the entire discretion of the CJI, if he deems it is proper to appoint a judge so that the backlog of cases may be sorted out, may be solved, then he can he can, with the consent of the President of India, he has to take the consent of the President of India, he has to give his submission to him, and then he can appoint another judge from the High Court who will be called as an ad hoc judge. Okay, so see, the ad hoc judges may be appointed by the CJI after consulting the CJ of a High Court, and with the consent of the Pres, a judge from a High Court, when appointed to the Supreme Court for some time, is called as an ad hoc judge. Okay, so I hope this is clear. Now we come to the following points. Keep the judiciary independent from the executive and the legislative control, thus ensuring its fearlessness. So if you want the judiciary to be on its own, if like in a democracy, all these three are very important. You all have already done it in your schools probably. The administration, the executive, the legislative, and the judiciary. These are the three important pillars of our democracy. So judiciary is one of them. So if you want to keep the judiciary fearless, then how will you ensure its fearlessness from the executive and the legislative control? Because they will try to control, but how do you make sure that they are not able to control? Now see, first thing I've given you a line. What is the meaning of jurisdiction? Because I think in those things that we did, in those terms, legal terms, which I had done with you, this thing was not given, but I thought it's important for you all to understand this, and that is the meaning of the word jurisdiction. What is jurisdiction? Jurisdiction means the power of a court of law to carry out judgments and to enforce that law. Okay, that is the power. So each court has got its own jurisdiction. Like for example, I'll give you, see children, I'll tell you one thing. Most of the time I give you examples of Mumbai, Maharashtra, etc. because I'm living over here. So that comes first to my mind. Okay, now the meaning of jurisdiction is, supposing the High Court of Mumbai has got, it controls everything in Maharashtra. It is a High Court for Maharashtra. Now if there is a particular case which is happening in Gujarat, okay, and they have a High Court over there, their High Court is in Ahmedabad. So if they have a High Court in Ahmedabad, they cannot deal with a case that is something that has happened in Mumbai unless there is a special clause in the contract which mentions that it is applicable to, or all the cases or any dispute will be referred to the court of Gujarat or the High Court of Gujarat. Otherwise, a High Court of Gujarat cannot judge something which has happened in Mumbai. The place where the crime has occurred has to be, so that is the jurisdiction of the Maharashtra court. And who is the head of, who is the High Court in Maharashtra? Mumbai. Okay, so each court has its own jurisdiction. You cannot cross your jurisdiction. Okay, that is the meaning of jurisdiction. Now we come to independence of the judiciary from the control of the executive and the legislature. We have Supreme Court and High Court. Like I've given you two. I'm doing both the chapters parallel. Okay. Now appointment. Every judge is appointed. We've already done this in detail. Every judge is appointed by the press after the consultation with the cabinet as well as the judges of the Supreme Court and High Court. The High Court of the Chief Justice appointed by the press in the High Court after consulting the CJI and the governor of the state. All the rest of the judges in the High Court are appointed by the press in consultation with the CJI, CJ and governor. How do you remove the judges? For both there are common points. Okay, which are the common points? They both can be removed only for proven misbehavior or incapacity. You cannot suddenly say, oh, I think this judge is like this, so we'll remove him. No, you have to prove his misbehavior, or you have to prove his incapacity to be able to judge. Only then you can remove him, for both. Okay, then how? The charge has to be proved by a joint session address of both in the Supreme Court. If you put such a grievous charge against a judge and say that he is incapable, or you say that there has been some misbehavior on his part, what will you do? There has to be a joint session of the parliament. That means the Rajya Sabha and the Lok Sabha. And the joint session of these two, the combined strength of the Rajya Sabha and Lok Sabha, 2/3 of the combined strength of the RS and LS have to be present over there, and they have to be voting, and after that vote there has to be a majority of the people who agree that okay, this particular judge has to be removed. Till then you cannot remove him. Now what happens in the High Court? This was for the Supreme Court. Now what will happen in the High Court? In the High Court, it has to be proved on an address in each house. The state legislature is also there, but each house is separate, and each house of the, they will prove over there in each house separately. Here it is a joint session, and this entire process of removing a judge by this majority of vote of 2/3, where more than 2/3 of the members are present and voting, is what we call as impeachment. Okay, I hope you have understood the meaning of impeachment. Now, as far as the High Court is concerned, we have an extra point which comes under transfers. Okay, so what are these transfers? In the High Court, the President can transfer any judge from one High Court to another, बट नॉट एट हिज ओन विम्स एंड फैंसीज कि आज प्रेसिडेंट उठ गए और उसको दिल में आया चलो मैं ये जज को उधर फेंक देता हूँ, इधर फेंक देता हूँ, ऐसा नहीं चलता है. It's not allowed like that. There is a particular system. Now what is that system? The president can transfer, but when? After consulting the CJI. So first and foremost you have to consult the CJI of the Chief Justice of India. The post of the Chief Justice of India is a very important post. Okay, so you have to first consult him. Then the CJI, before recommending or before agreeing to what the president says, he will not act arbitrarily. He will consult the 4 senior-most judges of the Supreme Court. The 4 senior-most judges of the Supreme Court will be consulted by the CJI that there has been such a motion or the president has expressed such a desire to transfer such a judge. Should we do it? Then there will be the pros and cons of that. Then the views of the CJI of both the courts, means the High Court, say for example the High Court of Maharashtra, that means the Mumbai High Court, and if that person is being transferred to Ahmedabad, then the Ahmedabad High Court. So the Chief Justice of Mumbai, the Chief Justice of Ahmedabad, they both will be consulted. So first you consult both of them, and then if everybody agrees, then that judge can be transferred. So transferring a judge is not something arbitrary. You can't just get up and do it. Okay. Then the judge who is transferred from one place to another, he is being removed from his place and he is going to another place. So that judge is entitled legally to his allowance, what we call as the compensatory allowance, apart from his salary. So his salary and emoluments will be there, but with that he will also get compensatory allowance because he is being transferred. All these points I've given you, I'll just read them, I've explained it to you. Okay, so let's read. The president can transfer any judge from one high court to another after consulting the CJI. The CJI, before recommending, will consult 4 senior-most judges of the Supreme Court. The views of the Chief Justice of both the concerned courts must be considered. The judge being transferred is entitled to compensatory allowance in addition to the salary. And so that is the way transfers take place. Supreme Court, there is no transfer. In the Supreme Court, once you are appointed over there, there is no transfer of judges in the Supreme Court, but a High Court judge can be transferred. Now we come to the tenure. I've already discussed the tenure with you all earlier. One is 65 years, one is 62 years. Now we come to the emoluments. I've done both parallel. The judge's salary, allowances, etc. shall not be changed to their disadvantage during their term of office unless a financial emergency is declared. What does that mean? Unless you declare a financial emergency in the entire country has to declare a financial emergency. A state, like you know what is the state of emergency. Similarly, if there is a financial emergency declared in the country, only then can the salary and emolument of the judge be reduced to his disadvantage, means to his to reduce the amount, only if there is a financial emergency declared in the entire country. Okay, now the amount, that means the emoluments and the salaries of the judges are paid from a consolidated fund. Okay, it is not paid from somebody's pocket, it is paid from the consolidated fund. If you are a Supreme Court judge, it is paid from the consolidated fund of India. If you are a High Court judge, it is paid from the consolidated fund of that particular state. Okay. So paid from the consolidated fund of India, and it is not subject to the vote of the parliament. Then this one is paid from the consolidated fund of the state, not subject to the vote of the state legislature. Meaning in the legislature you can't say that okay now chalo we are voting, reduce the salary. That is not allowed. Now punishment for contempt of court. A judge, the court means any judges, they can punish a person for contempt of court if its authority is lowered in any way. So if you misbehave in a judge, in a courtroom, if you say that okay I'm hungry now, I want to eat, so you start eating in a courtroom, that's not allowed. If you misbehave in the sense that if you start talking loudly amongst the counsels or with a junior counsel, with a junior advocate, with your clerk, all that is not allowed in a court. Okay, that's allowed only in movies. What you see in movies is absolutely different from what actually happens in the courts. So in the courts, all that will be treated as misconduct, and the court can charge you for contempt of court. You speak disrespectfully to a judge. You are supposed to respect his chair. You speak disrespectfully, contempt of court. Okay, both Supreme Court, High Court judges both have that power. Now we come to the establishment and procedure of work. Who is going to decide the procedure of work and about the procedure of establishment of the institute? Supreme Court and High Court both are same. The courts are free to decide its own procedure of work and its establishment, and also the conditions of the service of its employees. Children, have I given you this or am I just reading it? Oh, I think I have not given it to you. I'm very sorry. Please take it down. We come to the independence of judiciary. From there, I'll give you the notes. I've just been reading it, but you can read it by yourself. But I'll give you the notes. Okay, this is talking about the independence of the judiciary and from the legislature. Okay, I'm sorry, I've read it. I think I did not give you, but now I've given it to you, so you can read it by yourself. Now we come to the procedure of work and establishment of the procedure of work. The courts are free to decide its own procedure. Means the courts can decide what procedure they want to work and how they want to work. Then it can also decide its own establishment and the conditions and service of its employees. Now, for example, the courts will have their own security person, they have their own security team, they have their clerks are present, their assistants are present. Lots of people are working in the court. The court just doesn't work. So there are lots of people working. So the court or the judiciary has its own power and its own independence to decide what the working conditions of those people will be, those who are working connected to the judiciary or connected to the court. That can be decided by the judiciary itself. It does not need to go to the parliament to decide the working conditions. Okay. Then no discussion. There can be no discussion in the parliament on the conduct of any judges except when there is a motion for their removal. So when there is a motion for removing a particular judge, say from the Supreme Court, then only then there can be a discussion about such a motion. Otherwise, you cannot discuss any judge in the parliament. Similarly, in the High Court, you cannot discuss any judge in the state legislature, unless, of course, there is a impeachment motion which has been initiated till then. Okay, then we come to prohibition and restrictions on practice. So if you have been a judge and then when you retire at 65 and 62, what are the restrictions on the judges? It's not that the judges are having a gala time and that once they retire they'll start doing whatever they want. There are certain restrictions imposed on them even after their service. Okay, so that is very important. The judges of the Supreme Court are not allowed to practice after retirement. So once you have been a judge of the Supreme Court, you cannot practice law in any legal court. Okay, so that during their tenure they are not obliged to any prospective employer, because otherwise what could happen is that if the judge sees a particular person that, oh, he could be my prospective employer, then the judge might be biased against him. So that is not allowed. So you're not allowed to practice only. Now what happens to the high court? High court judges, once you retire from the high court, you can practice in the Supreme Court because you have been a judge of the high court, but you can go to a higher court. So you can practice in the Supreme Court or in those high courts where you have not served as a judge, where he has not been a judge. He can practice in those courts. He can also practice in the tribunals or other courts. He cannot practice in a tribunal, or he cannot practice in any of the city civil cause, small causes court, criminal court, any tribunal. He is not allowed to practice. So basically what this is trying to what you've got to remember is that once you have been on a higher stage, you cannot practice lower. That's not allowed, even after your retirement. Now, to announce decisions and decrees in the court chambers. Now, that is a power of the judge. That is the independence of the judiciary, that judges can announce their decisions and decrees in the court chambers without danger to their person or property. They cannot be criticized in the press or in public. Their safety is the concern of the government at both the levels respectively. So if you are in the Supreme Court has to ensure your safety. If you are in the High Court, the state government has to ensure your safety, because otherwise everybody will be threatening the judges. There was a recent mention which I read somewhere in one of the I don't remember where I read it, but we had one judge in the High Court of Mumbai. We had Justice Gautam Patel, and he had given some judgment in the year 2024. And after his retirement, he has been threatened. His daughter has been threatened. So now what is the safety? You have given a decree at that time, and then suddenly somebody decides to threaten you. So then at that time the safety of the judges and their family is a concern of the government. The government has to ensure that they are safe. Have you understood? So we've done so much. Now like I told you, I want you all to open your textbooks so that I can tell you how much we have exactly covered today. Okay. Today we began with the independence of the judiciary from the control of the legislature. That is what we began today. Okay, so I have done, that is on page number 242 or 243, and that is the Supreme Court. Then we come to the High Court. I have covered that also. You can tick mark those topics over there. Independence from the judiciary. Those entire 10 points have been covered. And we come to the High Court, where I have covered all this: qualification, appointment of judges, conditions of service, then retirement, removal, transfer, salaries and emoluments, restrictions on practice. Please keep taking restrictions on practice. All this has been covered in this module today. And of course the independence of the High Court, which is given to you on page number 257. So independence of the High Court, 257, and a part of it is given on 258. I have covered up all this with you today. So 257 is done, and we've covered up High Court and Supreme Court, how the independence of the judiciary is protected from the legislative and executive. Now you know there is a picture on your page. If you open, you have a picture over there which gives you powers and functions of the Supreme Court. Do you see that picture? Okay. Now in that picture they have given you a diagram, and there is original jurisdiction, protector of fundamental rights, appeals, all this also we are going to cover, but I'll be doing it in my next module. The reason I'm showing you these pictures is, and I'm drawing your attention to the picture, is even on page number 241, where we have the picture of the Supreme Court at the beginning of the judiciary. You must look at these pictures, because these can come as your picture questions. Any picture which is given in your textbook can be posed as a picture question. So it's very important that you catch hold of your textbook and don't depend only on notes. You can do both. So the notes, I mean my notes I'm talking about, my notes are given in a simpler form, stressing only on the important things so that you can write that in your exam. But the pictures is something that you must read from your, you must go through your textbook, because your textbook will give you a true picture of everything and you will be asked questions on that. Okay. Like at the end of the Supreme Court Judiciary, they have given you a question on the picture. They have put up a question of the Supreme Court and it has been asked, which court is this? Okay, study the picture building and where is it located, which court is it. So unless you see the pictures, you won't know that it's a picture of the Supreme Court. You have to know what is a picture of the Supreme Court. Okay, so please go through the pictures also. So with that, I have done a lot of topics with you. And just in case you feel that, of course, the last one is live streaming of court proceedings. I forgot to mention that. Live streaming of court proceedings, because now we have all the courts, even the Supreme Court, even all the high courts, there is a live streaming going on so that the transparency is increased and the judiciary is independent in every way. So if you want to see what is going on in which court, all you have to do is connect to the right thing and connect to the right, what is it called? The right link, and you can watch the live streaming. Okay. Now, as far as you students are concerned, I've got a little acronym for you. Just suppose you feel it's difficult to remember these points on independence of the judiciary and the from the control of the executive and the legislature. How will you do that? I've got a shortcut for you. I'll write it down for you. See if it helps you. And this is the way in which you form your own acronyms so that it becomes easier for you. I'm writing it out for you so you can see it. So for this independence of judiciary, you can put this point. Arts Pen Pal. Okay, if you remember Arts Pen Pal for independence of judiciary, you will get all your points. Now we look at my notes. How do you remember this Arts Pen Pal? I'll give it to you. First one, appointment. A for appointment, R for removal, T for tenure, S for salaries and emoluments, P for punishment of contempt of court, then E is for establishment and procedure of work, N will be for no discussion, P for prohibition and restrictions on practice, A for announcing the decisions and decrees, and L is for live streaming. So in this way you can easily remember all the points which make a judiciary independent from the executive and the legislature. So with that I come to an end of this one, and we'll continue next in my next module. We haven't finished the judiciary because I'm covering 2 chapters simultaneously, so it's not going to be so easy to complete it. So I will be seeing you all in my next module of the judiciary, where we shall talk about the jurisdiction of the Supreme Court and the High Court. What are the powers of jurisdiction and what are their functions? So we've still got that to cover. Yes, I think we have to cover that. So I'll be covering the jurisdiction of both the courts, and then we'll see how much we are able to cover and how much we still need to go on and what needs to be done. So then see you all again at my next module. Till then, please remember Arts Pen Pal, and Arts Pen Pal will help you to remember how the judiciary is kept independent from the legislature and the executive, from both. Okay, judiciary is very important. Bye everyone.